Well, hello and welcome once again. Employment Law Show. John Scholes here. Lior Samfiru as well. Lots of this good stuff coming on the show today, folks. And for you, Lior, as well. I know you're anxious to get into this. 5 things to do to make sure your severance is fair. This is huge. Do not miss this part of the show because it affects so many people. Throughout the show, we're going to give you contact information as well. You want to reach out, 1-855-821-5900 by phone, help@employmentlawyer.ca. And there's also a website which will be referred to several times during the show, and that is pocketemploymentlawyer.ca. That is absolutely free and anonymous, but is like having Lior with you 24/7. In fact, you can go there even before making the phone call to contact Lior, and maybe it's got all the answers you need. But we always start out, pal, with the week that was. What is going on your end?
Hey, John, I'm looking forward to the day that we can get on this show or that I can spend time in the office not talking about COVID-19. I'm looking forward to that, but today is not that day. In that today, still, COVID-19 issues impact the workplace, impact your job. I deal with these issues every day. They raise new questions, new problems. So like we do on every show, like we've been doing for many months now, we're going to touch on how these rights that you have are impacted by COVID-19 and what to do if your job has been impacted. Okay. Despite that, I want you to remember the rule. COVID-19 or not, you still have rights. COVID-19 has not extinguished your employment rights. Your rights as an employee, the obligations that an employer have, they are still there. So we're going to try to educate you on this show like we do every time about what to do if you lost your job, COVID-19 or not, if your job has changed, if you're off work, if there's job security issue, if you're being mistreated or harassed, whatever the issue is, we'll give you answers on this show. We'll give you solutions on this show so that you know what to do if that ever happens to you. And of course, as we always say, if you want to have a private chat about something, about your specific issue, don't hesitate to reach out. We'll give you contact information throughout the show. But to get us started, let me tell you about a situation that came across my desk very recently. And this one, of course, deals with COVID-19, and it brings to light the issue of what it means to be an essential business or an essential service these days. I spoke with a gentleman who had been suffering with a bad knee for quite a few times, for many months. He was supposed to have surgery on his knee. Because of COVID-19, that surgery got postponed again and again. Now it got to the point very recently where he could not actually continue working. He had to go off work because his knee was so bad. So he got his doctor's note, he went off work. Now his employer, once they realized he's going to be off for more than a few days, contacted him and said, well, we are an essential service. We're in construction. We're allowed to continue operating. Because of that, we can expect our employees to come into work. You can't come into work because of your knee. So we're going to consider you to have resigned. We wish you all the best. Goodbye. Well, obviously very confused and certainly upset, this gentleman called me. And he wanted to know, well, what are my rights? Does this make sense? Can they do this to me? Well, the answer, of course, is an emphatic no. His employer cannot do this. His employer cannot consider him to have resigned. And here's the thing. All he needs to be off work is that doctor's note. If he has a medical condition that's legitimate and he has that doctor's note, he can be off work as long as necessary. The fact that the business is an essential service, the fact that they're allowed to operate as they were pre-COVID does not change the law, does not put the company above the law. They can't consider him to have resigned. He has a legitimate medical issue. He can be off. So same thing with you. Regardless of what business you work for, regardless of how your company is operating right now, whether it's at full capacity or otherwise, if you have a serious medical condition that you need to be off work because of, get that doctor's note. Once you have that doctor's note, your employer cannot do anything to you. They cannot let you go. That's not a resignation. You are protected. Please remember that.
It's interesting, too, the language that was used, because they can't assume he's resigned or told him he's resigned. That's not a resignation at all. That's being terminated.
Yeah, anytime someone says, we assume that you've resigned, that's nonsense. It can't happen. The only one that can decide if you've resigned is you, the employee. If you've made a decision to resign and you've communicated that decision, then you can resign. There's no such thing as an assumed resignation. Anytime your employer says, we'll consider you to have resigned, we'll assume you have resigned, you better resign or else. None of that is legitimate. None of that is legal because you can make that decision and only you. If that ever happens to you, if your employer says you've resigned, you call me and let me deal with it.
Another website you can go to anytime, employmentlawyer.ca. While you're there, tons of information, as there always is. There's also links to our long-running radio show, which is how we started this partnership between you and I so many years ago. And every week across the country, we get tons of phone calls on the shows. We like to cherry pick a few of them, play them back here, Lior, and let's talk about them. So phone call number one is coming up now.
I was a permanent part-time employee, and our department were told that there were going to be 4 positions laid off. I worked for the firm for 4 years, accounting clerk, 53, and they have given me a severance package. I was told it would be in my bank account this past week, but it was not.
This is an issue, John, that I deal with often, and that is part-time employees. There's all this assumption, I guess, some people have, well, a part-time employee may not get severance or may not get as much severance. Right. That is, of course, wrong and false. So she is a part-time employee. She is owed severance. So the question, of course, becomes how much severance is she owed? Remember the main factors that go into assessing severance: your age, your position, and the length of your employment. Now, that's what she needs to determine, is how much severance. Once we know how much severance, chances are that her employer has underpaid her or offering less than she's owed. How do I know that? Well, I know that because that's what happens in over 90% of cases. So rather than just talk hypothetically, let's talk about this specifically. Let's take this caller's information and let's plug that into pocketemploymentlawyer.ca, into our severance calculator tool that you can find there. And let's see how much she is actually owed. So we know she's in a clerking job. She's a part-time employee of 4 years. She's 53 years old. Now, we don't know exactly how much she was offered, but here's what we do know. You can see on the bottom of your screen, we know that she is owed about 6 months' pay. 6 months' pay. Now, part-time employee, remember, that doesn't change the fact that she gets 6 months' pay. If her employer is not paid her this amount or is not offered this amount, it's not something that they're planning on paying, well, unfortunately, they will have to. And that's my job to make sure that happens. So full-time, part-time, you still have significant severance rights.
You have questions, by the way, anytime we're not doing this show or any other, terminationquestions.com. Again, terminationquestions.com. It's free. It's anonymous. You can use that anytime you like. Want to get to our first one for today, Lior, so let's get into it. Leanne is up. She says, can my employer fire me for poor performance, even if I'm trying my best at doing my job? I'm only owed 2 weeks' pay when I'm let go in the case. Really? So
the real question is not, can she be let go? The real question is, can she be let go for cause? Now, an employer, remember, can let you go pretty much for any reason, even if your performance is very good. Your employer is allowed to let you go so long as they pay you your proper severance. Now, what she's really asking is, if my performance is kind of so-so, can my employer let me go for cause? In other words, can they let me go without having to pay me any severance? Now, the answer to that is generally no, absolutely not. Why? Because the only time your employer can let you go for cause without severance is if you've done something very, very bad. So in terms of performance, number one, your employer would have to show that your performance really legitimately and objectively was very bad performance, number one. Number two, your employer would have to show that they've made efforts to try to fix your job issues, that they've given you opportunities and warnings and even training and support, and you still are not able to do it. Then maybe then your employer can consider letting you go for cause. That's very difficult to do. Very, very difficult to let someone go for cause because of performance reasons. So yes, chances are for Leanne, she is owed her full severance. Remember, that severance can be as much as 24 months' pay. So if you have bad performance issues, according to your employer, that does not allow them to let you go for cause.
Coming up here, 5 things you need to do to make sure your severance is fair. This is key information, so stick around for it. We'll get to that. In the meantime, reaching out simple, 1-855-821-5900, help@employmentlawyer.ca as well. Stick around, coming right back. Employment Law Show. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us. We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes, Lior Samfiru. This is key information, Lior. I know we want to get right into this. 5 things you need to do to make sure your severance is fair. The first one, and this is why we're taking this time to do this, is exactly that. Just slow down, breathe, don't rush to anything, get through all these points, and you'll come out better at the other end, correct?
Well, John, the reason why this is important to do these things to make sure your severance is fair is because it's not going to be fair automatically. Over 90%, I said this before the break, 90% of the time, that's pretty strong odds, your severance is not fair. That piece of paper that you have in front of you which outlines what your employer is offering you when you lost that job is not fair, not even close to being fair, meaning it's now up to you to do these things that we're going to talk about to ensure that you get what the law says you should have. And you're right, this is a stressful time. Losing your job for many people, for most people, is a very stressful time. So it can be easy to make bad decisions and rash decisions. Please don't let that happen to you. Think about what you're doing. We're going to give you some pointers now. Do the right thing.
Okay, number 1 is this: determine the exact reason for your dismissal, right?
Now, this is important because we want to understand whether your employer is letting you go supposedly for cause or not for cause. Now, if your employer is letting you go supposedly for cause, in other words, you've done something according to your employer that's so bad that you deserve to be let go, to be fired without any severance, you want to understand what they're saying happened, what they're saying that you've done, and what the employer has to support it. So if they're saying that you did a bad job, what did you do the bad job on? What is it, a particular project? Is it generally? Is there any documentation? If they're saying you mistreated someone, what is the allegation? When did you mistreat someone? Who? How did it happen? So we want to get those particulars so that we can assess your situation. Now remember, if your employer is saying, no, we're letting you go on a without cause basis with severance, at that point the reason doesn't really matter too much. But if your employer is making allegations to fire you without severance, yes, we want to understand as best we can why you're let go. Ask the right questions, ask for all the information so that we can assess your situation.
We are talking about things you need to do to make sure your severance is fair. Number 2 is go over your employment contract, assuming you have one, right?
Right. So first of all, if you don't have an employment contract, this whole time you've been working on a handshake agreement, consider yourself happy and fortunate. Okay, that is a very good thing. I know it sounds strange for people that have not heard us speak before, but not having an employment agreement when it comes to your severance is probably the best news you can have. Now, if you do have an employment agreement or a contract of employment that you signed at some point, you want to go over it. You want to understand, are there terms in that document that try to limit your termination entitlements? What some employers do, even a lot of employers, is they include in the employment agreement a term that tries to reduce what they have to pay you if they let you go. So let's see what that says. Yeah, you may not be able to make sense of it. You may not be able to understand what it does. Send me a copy of it, okay? Send me a copy of the employment agreement, and I'll be able to tell you, does it limit your entitlements? Does it not? Can we get around it? Can we not? But having that employment agreement, reviewing it and understanding it is key to ensuring you get what you're owed.
Number 3 is this, and it speaks to what we talked about at the beginning of the list, is just slow down, take your time. Don't be in a rush to accept that offer. That could kill you.
That severance offer, John, you know this, we've spoken about this many times, is going to have a deadline on it, right? It's going to say, to accept this fabulous offer, it's not so fabulous, by the way, that we're offering you, you better sign this back and give it to us by Friday or whatever the date is. And that's a pressure tactic, and you will feel that pressure to rush and accept it because you don't want to lose it. That's natural. Here's the thing. Do not worry about it. Your rights, your legal rights, don't expire on Friday or Thursday or any other day. You have 2 years to enforce those rights. It's 2 years before your rights actually expire. So don't worry about that deadline. It's a pressure tactic. You can tell your employer, I'm going to respond when I'm ready. Okay? So that That is what you have to do. So many people, because of that deadline, sign it, and then it's too late. You may sign it and then realize, holy cow, they owed me another year's pay. I see that daily, multiple times a day. Don't let that happen to you. So please do not rush without getting advice, without understanding what you're signing, without reviewing your employment agreement. Do not rush and sign off on that severance offer.
We are talking about 5 things you need to consider to make sure your severance offer is fair. Number 4, I guess, and this one's a good tip of the hat to pocketemploymentlawyer.ca and severance pay calculators, that take time to figure out what are the components that make up that severance offer. How do they get there?
Yeah, so first of all, let's remember that it's not just your length of employment that matters when it comes to your severance. It's not a situation where, I get a week per year or a month per year. There's a number of factors that go into assessing what you're owed. Your age, your position, the length of your employment, whether you've been recruited from another job, whether you've been let go because of a harassing reason, harassment, whether or not the economy is good or bad. There's a number of multiple factors that could significantly increase your entitlements. By the way, right now, during COVID-19, you're actually going to be owed even more severance than usual because it's potentially going to take you longer to find another job. Now, one way to get a very good, helpful, and quick assessment of your rights, of your entitlements, to assess those factors, is simply to go to pocketemploymentlawyer.ca. When you go to pocketemploymentlawyer.ca, you will see our severance calculator tool. You can answer a few questions, and in seconds, you will get an assessment of how many months of severance you are owed. It's free, completely free. It's easy to use. It's also completely anonymous. You don't have to put in anyone's name. No one ever knows you've been there. It's for your information. And if you want, you can contact me, if you want, directly from there. So to assess those factors and how they apply to you, go to pocketemploymentlawyer.ca.
And I think, as an aside to that is figuring out all the components of that severance, Lior. You've also talked about the fact that it's not just your pay or how much holidays you get, it's all the components, especially if you're in a sales position, you have a company car, or, you're working on a commission basis as well, right? You got to consider everything.
That is so true, because it's not just those basic, pay and benefits. It's everything that has to be included in your severance. Commissions, car allowance, bonuses, RSP contributions, pension contributions. I can keep going. All those have to be included and accounted for in your severance. So if your boss said, we're going to give you 12 months of base salary, well, the first question, of course, is 12 months enough? But the second question, and just as important, is, wait a second, why is it just base salary? What about all the other components of my compensation? Because they have to be included as well. And if you haven't gotten what you're owed, that's what we call a wrongful dismissal.
And number 5 could be the most important one, but the easiest one, that is reach out to you. Contact Lior with any other questions, or if you're just not totally positive everything's on the up and up, right?
Signing off on that severance offer is a big deal, because once you sign on that dotted line, you're done. There's no going back, right? There's no saying, well, now that I know it's bad, now I'm going back. No, you're done. You only have one shot to do this right. That's why I say, I've given you some tips right now how to assess your entitlements, and even the handy-dandy pocketemploymentlawyer.ca. But to know for sure what you're owed, not to leave anything to chance, not to take any risk, is you have to give me a call. If you lost your job and you're staring at that severance package, let's have a quick discussion to determine whether it's fair or not, and if it's not fair, what to do about it. How do we get you what you're owed? And by the way, the reason why we spend so much time talking about this is that when I say your severance package is 90% of the time unfair, I'm not saying that, well, they've offered you 6 months and it should have been 7 months. I'm telling you that in most cases, when they've offered you 6 months, it should have been 15 months. Those are the types of differences that I see every day. So please don't let that happen to you. Don't sign off on that offer without speaking to me first.
Okay, as mentioned, employmentlawyer.ca, that's a website you go to. You want to find a radio show across the country. The network is always growing. We're always adding stations to that, so you can catch us probably no matter where you are, pretty much from coast to coast to coast. If not, we're going to be there soon, trust me. And we get a ton of phone calls, as I mentioned in the first segment as well, from the show. Lior, let's get to our second phone call from the radio show now.
Worked for a company for 33 years. A new company came in, took over the old company, and they made us sign a 1-year contract. Keep my same job, keep my same position. After 1 year, if they decide to let us all go, do they pay us 1 year or do they pay me 34 years?
I love this phone call. Love this.
Yeah, I love this phone call, and it's a reminder also as to why it's so important to make sure we always review an employment agreement before we sign it, okay? So yes, if you are now signing a 1-year contract, well, that means first of all, your employer inherited your service, okay? So the new company that bought it inherited the service. If you sign a 1-year contract, means that 1 year counts towards your severance. But because this gentleman has been there for 33 years, he's probably owed 2 years severance. So at the end of the year, he would then arguably still be owed 1 more year's pay. Now, I probably would have advised him not to sign this agreement or to negotiate that agreement. But in this situation, that's what I tell him. If you are signing an agreement that limits your entitlements or are asked to someone, let's talk about it first. If you've received advance notice of termination, that may reduce your severance entitlements, does not eliminate them, okay? So very important to get some advice before you do anything.
You know, we've often talked about that when you're in mid-employment and they come to you with a contract, you have to be given some consideration. They have to give you something for signing it. Does that apply in this case or no, because it's a whole new company?
It wouldn't apply here because the consideration here is the fact that the new company came in, they didn't have to offer him a job, but they decided to offer him a job. Right. So for him, that's okay. But if you're working for the same employer, I had a case earlier this week where a gentleman had worked for his employer for 2.5 years, and his employer says, well, we never remembered to have you sign an employment agreement back then, so we want you to sign an employment agreement right now. He did. 2 months later, he's let go. Now the company says that agreement that you signed limited your severance. So unfortunately for you, we can let you go and pay you a lot less. But because he never got anything in return for signing that agreement is not enforceable. It doesn't limit his entitlements. So please, that's another reason why if you're ever let go, if you're ever offered an employment agreement to sign, please do yourself a favor. Talk to me first.
We will take a short break and grab another phone call from our radio show, but we'll take a pause before we do that. 1-855-821-5900 to reach out by phone, and the email help@employmentlawyer.ca. You're still watching the Employment Law Show. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. A few minutes to go. Employment Law Show. Yeah, like he said, employmentlawyer.ca. That is where you want to go. That is also the route to take if you want to find a station, radio station near you that carries our show. Lior, phone call number 3 from one of our loyal listeners is coming up right now.
I've been 33 years as a truck driver. 3 people got let go or quit on my shift that used to be 4 people. I'm now the only person on this shift, and I have to do the bulk of the work for the people that are there, and it's been a year. They have not hired anybody back, and my workload's gotten worse and worse and worse. Is that really fair? Because now I'm working longer. What can I do about that?
It's been a year.
You know, it's one of those things, Don. Like, we hear a lot of stories during COVID-19, people saying, I don't have work or there's not enough work for me. But there's also people like this gentleman that are saying, I have too much work because maybe other people have been let go and now I'm doing the job for 2 or 3 people. So what do I do? So here's the problem for the employers. If you're now doubling someone's workload, well, you're changing the terms of employment. An employer does not have a right to change terms of employment unilaterally. We call that a constructive dismissal. So yes, if your employer all of a sudden doubled your workload, give you a lot more work, no more pay, but just a lot more work, even if it's COVID-19 related, that could absolutely be a constructive dismissal if you want it to be. If you're in that situation, give me a call. Now, the problem for this gentleman is he said that some of those things happened a year ago, these changes, and by now he may be considered to have accepted those changes, the fact that he's doing more work. But here's why I may not be worried about that. If his employer keeps telling him, okay, we're going to bring someone, it's okay for him to give them that opportunity. Now that it's been that long and they haven't lived up to what they promised, now he can potentially say, that's a constructive dismissal. Enough is enough. I'm not going to do the job of 2 or 3 people because that's not what I signed up for.
Right.
So if this is a constructive dismissal, let's go to pocketemploymentlawyer.ca and let's determine how much this person is owed after all these years that he's been there. So let's open up our pocketemploymentlawyer.ca, our severance calculator tool there, and let's see, this person has been there for 33 years, a long time. He's in his 50s, and his employer didn't offer him anything because this is a constructive dismissal. But as we see at the bottom of the screen there, he is owed anywhere from 18 to 24 months, probably closer to 24 months of severance. Okay, that's what's at stake for him if he chooses to treat this as a termination. And remember, John, his employer didn't let him go. This is what we call a constructive dismissal, but the severance is still going to be the same.
We'll get to another question from terminationquestions.com. That is available for you to use anytime, terminationquestions.com. Lior from Stephen. Stephen says, do I have to get my boss's approval before taking time off work to deal with some mental health issues?
So this is a very good question. And you know, during COVID-19, again, here's that term again, COVID-19, mental health issues have been on the rise. It's a very stressful time to try to manage our health, our family's health, manage kids off school, doing our job, financial issues. For many people, that's caused stress and anxiety and depression. And I've seen the significant rise in mental health issues happen over the past year or so. So do you need to get your employer to approve time off? No. And the reason why you don't need that is because having a mental health issue is just as a legitimate medical issue as if it was a physical ailment. So what do you need if you have a mental health issue, then you cannot work? A doctor's note. It's as simple as that. And by the way, it doesn't even have to be from a psychiatrist. It could absolutely be from your regular family doctor. If you have a doctor's note saying you cannot work, then you can be off work. Now, for many people, by the way, having a mental health issue, they may find that something that it's very personal. They don't want to share that with their employer. They don't want to tell them why you're going to be off work. That's fine. Your employer does not, this is important, does not have the right to know what your condition is. Maybe you have a bad back, bad knee, or you have a mental health issue. That does not matter. Your doctor doesn't have to say what the issue is, only that you cannot work for medical reasons. If you have that doctor's note, you can be off until your doctor clears you to come back to work, mental health issues or not, and you don't need permission from your employer to do that.
They're generally allowed to ask how long you think you'll be off. Prognosis versus diagnosis is what you're saying, right?
So your employer can ask questions about your prognosis. How long are you expected to be off? When are you going to give us an update? Is there any accommodation that you need? Those are all legitimate and proper questions. What your employer cannot ask is, tell me what your condition is. Tell me what you have. Tell me what medical treatment you're getting. Those are personal, private, and your employer has no right to know any of this information.
And just before we go, Lior, in a minute here, to reiterate, things have increased and have improved as far as severance because of COVID-19. A lot of people think the opposite, right?
Well, one of the factors that goes into assessing how much you're owed is how long should it take you, we think, to find another job. So right. Booming economy, a lot of jobs, yeah, potentially less severance because you can find a job faster. Right now, less jobs, more difficulties in finding a job. That may mean even more severance than usual. Very important to remember.
Good way to wrap it up for today. Reaching out, 1-855-821-5900. And you always go to pocketemploymentlawyer.ca. Free, anonymous. It's like having Lior with you 24/7. We'll catch you again. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.